Now, sir, I have to be clear and fair to you. There could be a perfectly innocent explanation. There may not be. Why did you use his name, first of all, to acquire the insurance?
Because the bike's registered to him.
That's one answer. And you were going to put yourself down as a named driver, is that right?
Yes, correct, sir.
So it would have been cheaper, correct?
Correct.
There's no problem with that. That's what I'm trying to understand. Did you ensure that that insurance covered you for theft?
No, sir.
Did it cover you for theft?
No.
What happened in May? To the bike, sir?
The bike was taken, sir.
It was stolen. You weren't, at that stage, covered by insurance. Did you inform the police of what happened?
Yes, sir.
And what happened?
They said no further updates.
What's your claim for, sir, today? How much for?
My claim is the settlement status before his last payment, which is £4,825 and 45 pence.
And in fact, you've sent some chasing messages. Let's have a look. Look. What does lol mean?
Laugh out loud, sir.
You're laughing out loud? Laughing out loud?
Yes, sir.
So this is you having got finance out, him into considerable debt, and you find this considerably funny, do you?
At the time, sir, yes.
The texts mean nothing when it comes down to it. You took out the finance at your own. Well, I did not force you to. So at the end of the day, no matter what happens, you will end up paying for the finance. Read out the next one. The bottom. No, you read it, sir.
Okay, I thought you were my friend, but apparently you don't give a damn.
What did it do to you, sir, when you discovered that his attitude was your problem? How did you feel? Tell the truth.
Okay. I was trying to chase him for the payment, but as you can see, all he was saying that he didn't care.
Sir, your legal submission is twofold. The first one I've construed on your behalf. You say, I'm helping you in this regard. I have to because you don't attend with a lawyer today. You do not have a legally enforceable contract against me. Correct?
Correct.
Read that out. I'd like to hear it in your voice.
Look, Lo, the text means nothing when it comes down to it. You took out the finance of your own will, and I did not force you to. So at the end of the day, no matter what happens, you will end up paying the finance.
Sir, would you explain to me, before I come to ruling, what you mean by that, sir? Because it's important that I understand fully the basis upon which you make a defence in this case.
Well, as the sales representative explained to him, he took out the finance in his name. If something happens to the bike, he'll be liable for all payments.
Why then did you make several payments over a period of months?
Because we agreed that when I use the bike, I would be paying for it.
Well,
Which is only fair.
Did you imagine at some point he would be using the bike?
Yes, sir.
You imagined that he would be riding this motorbike?
Yes, sir.
Ever ridden a motorbike before?
Oh.
Ever expressed an interest in riding a motorbike with him?
No.
When did he express an interest in riding a motorbike?
He said that his dad and him used to own a motorbike back in Italy.
Did that ever happen?
My father has a motorbike, but
Did you ever express to him an interest in owning this motorbike? Did you ever have it in your house or say that you would take it away from him in due course?
No.
Anything else?
No, sir.
Lorenzo, Mark, the overriding duty of a judge in any case is to do justice in the proceedings. Sometimes the law and justice are not necessarily the same thing. Lorenzo, you did something deeply stupid, which was to take out finance for Mark, who I consider to be a thoroughly undecent individual, certainly in the course of his conduct with you. You, as he correctly says, are legally liable to that finance company. What's more, you are responsible for all of the obligations under that agreement, including the term which expressly says that you must have insurance cover for theft. You failed to ensure that he had that relevant insurance. That, at the start of this case, should be the end of the matter. Secondly, once you got this finance out for him because he was a beneficiary of this motorbike, The next thing that you needed to do was to get in writing an agreement between the two of you, making it palpably clear that he was responsible as a debt each month to pay for the finance that you took. In other words, you had a separate legally enforceable contract. During the course of the proceedings, I have seen text messages, and critically, on your behalf, there were at least 3 separate occasions in which he made, to his limited credit, full payments. That gives me a clear and unequivocal indication, so that I'm more sure than not that he understood that he was liable to pay this loan. And he only stopped paying it when the bike got stolen and didn't want to pay for it anymore. Consequently, by the narrowest margin, I am prepared, doing justice in this case, to come to the view that he owes you for the full value of the loan you took, by the narrowest margin. And therefore this court awards you the full sum for the bike of £4,825.45, with a very stark and severe message. Don't deal with morons and get everything in writing. You understand? Understand?
Yes, I do.
How dare you tell me that this bike was going to be for him? How dare you not get proper insurance? And how dare you not pay him when you ought to have done? This court awards you £4,825.45. Don't be stupid. Stay and watch the best Judge Rinder moments. And I'm talking. Understood? Don't be a moron. Subscribe to Judge Rinder YouTube channel. Right now. That's an order.